Welcome to the Bank Pension Updation Deep Dive. Today, we're looking at a significant legal judgment from Delhi High Court in the civil case number WPC number 11234 2020. Judgment date 10 April 2024 before the bench of Honorable Justices Manmohan, Acting Chief Justice of the Delhi High Court, and Manmeet P.S. Arora. I am Priyanka Chakraborty and my co-host is Anil Agrawal.
Before the bench were three core legal questions. 1. Whether Regulation 56 mandates periodic revision or updation of pensions along with bipartite settlements. 2. Whether absence of DR neutralization and pension stagnation amounts to violation of fundamental rights. 3. Whether courts can compel the IBA Union of India to devise a pension updation formula.
The Honorable Court interpreted Regulation 56 as a forward-looking enabler, permitting and even encouraging pension adjustment in light of market conditions. But more on the full judgment later.
The bench seemed to have fundamentally shifted how we view pensions in India. They treated a pension not as some kind of handout or a bureaucratic allowance, but as a protected constitutional right, basically a deferred wage, something earned.
Okay, so which specific case are we digging into today?
This is the All India Punjab National Bank Retirees Welfare Association versus Punjab National Bank and others. The decision landed on April 10th, 2024.
And why all the buzz? Why is it being called progressive and extremely pro-bank retirees?
Because it tackles this core tension, this clash between fundamental rights, like the right to a dignified life, and the bank's arguments about, financial constraints.
Our mission then is to unpack why this ruling is seen as so rights-based and strategic in how it handled that clash, and whether there's a hidden agenda behind why the Supreme Court asked for this particular case as one of the three reference cases after reserving judgment on October 9th, 2025 in the MC Singla case.
In order to grasp the importance of this case amongst many others in the pantheon of pension updation lawsuits in India, it's crucial to start at the beginning.
The petitioners represent retired officers and staff from Punjab National Bank (PNB).
They'd seen current employees get salary hikes multiple times under what are called the 10th and 11th bipartite settlements.
Right, those are the regular wage negotiation rounds.
Precisely. But their pensions, they stayed frozen for years.
So, while working folks kept pace, more or less, with rising costs, the retirees fell further and further behind, they argued.
This caused a severe, almost catastrophic inflationary deterioration of their pension's actual value, without any prospect of long or short-term improvement.
That disparity felt inherently unfair, but unfairness isn't always illegal. So where did they anchor their legal argument against institutions like PNB?
They had two main pillars. First, an internal rule. Regulation 56 of the Bank Pension Regulation.
Regulation 56, what do they claim it meant?
They argued it wasn't just some dusty old rule, but that it actually mandates pensions should be updated. Kind of like how salaries get updated through those bipartite settlements.
Okay, so linked pension updates to salary updates. And you mentioned dearness relief or DR?
Yes, that's crucial. DR is supposed to protect against inflation.
Right.
Part of their argument was that the way DR was being applied, or rather not applied equally based just on when someone retired, was also part of the problem. It needed proper neutralization.
So internal rules first, but then they brought out the big guns, the Constitution.
Absolutely. When the internal rules argument isn't enough, you escalate. They claimed violations of three key articles.
Which ones?
Article 14, which is about equality before the law. Article 21, the right to life, which courts have interpreted to include the right to live with dignity, especially in old age.
Makes sense. And the third?
And Article 300A, the right to property. The idea here is that an earned pension is a form of property.
Wow. So equality, dignity, property, that's a powerful combination. It must have put the banks and the system on the defensive.
Definitely. It basically challenged their entire retirement framework.
So this set of three core questions the court had to answer, didn't it? These weren't minor points.
No, they were fundamental. First, Does Regulation 56 actually require periodic pension updates alongside those bipartite settlements? Or is it just optional discretionary, like the banks were probably arguing?
Okay, mandatory or optional? What was the second?
Second, does letting pensions stagnate like this and having these unequal DR rates actually violate those fundamental rights, Articles 14 and 21?
The constitutional test.
Exactly. And third, maybe the trickiest one, can a court actually step in and compel bodies like the Indian Banks Association, the IBA, or the government itself through the Department of Financial Services?
Compel them to do what?
Compel them to create a concrete working formula for updating these pensions. That's a big step for a court.
Yeah. Courts usually shy away from telling the government exactly how to spend money or structure complex financial systems. A textbook example of the separation of the responsibility of the judicial from the executive and vice versa.
So let's tackle that first point, Regulation 56. How did the court interpret it? Did they buy the bank's argument that it was, just sitting there and not doing anything?
Not at all. The Delhi bench completely rejected the idea that it was dormant or merely discretionary.
Really?
So what did they say it was?
The bench called it a forward-looking enabler, a living regulation. They said it clearly shows the legislature intended to allow for periodic adjustments, recalibration based on changing economic times.
That's a very different reading, not passive but active potential.
Precisely. The court basically said this rule exists for a reason, and letting it sit unused for decades defeats its purpose.
And what was that purpose according to the court?
To uphold the idea of pension as a deferred wage. They stated explicitly that long gaps without review defeats the object of pension as a deferred wage.
Let's stick on that phrase deferred wage for a second. That sounds important. If it's a wage you earned earlier but received later,
Then it's not a gift, not a charity. It's something owed, something due to you by law.
and if something owed loses most of its value due to inaction,
Then the entity responsible for upholding the regulation hasn't fulfilled its obligation. That's the implication. It shifts the burden. It makes maintaining the real value of the pension much more of an active duty for the bank.
which leads straight into the constitutional findings, right? Particularly Article 14 equality.
Yes. The court looked at how dearness relief was calculated differently for retirees who left before 2002 compared to those who left after.
And found that difference discriminatory.
Discriminatory in effect, yes. It failed the Article 14 test because the difference wasn't based on any intelligible formula.
Meaning there wasn't a logical, legally sound reason for treating these two groups of retirees differently just based on that cutoff date.
Exactly. It seemed arbitrary. And when that arbitrary financial harm combines with massive inflation,
Then Article 21 comes into play, the right to a dignified life.
that's where the court went next. They explicitly linked the financial reality to the constitutional need to protect people in old age.
They said, and I'm quoting loosely here, that pension stagnation, especially when you see rising wages for current employees and soaring inflation, creates a constitutional anomaly.
An anomaly that impacts dignity.
This is where it gets really stark, isn't it? Was there a specific piece of data that drove this home?
Oh, absolutely. The judgment wasn't just based on legal principle. It included some shocking data analysis.
Like what?
It found that the real income value, what the pension could actually buy for many bank retirees, had plummeted, declined by over 80% in the last couple of decades because it wasn't updated properly with DA and salary benchmarks.
80% loss of value. Devastating. Not just an inconvenience, that's potentially pushing people into hardship and existential.
It's a staggering figure. And the court didn't just state it. They included charts and an appendix showing this dramatic loss of parity between older and newer retirees. The evidence of widespread financial erosion was right there. You couldn't miss it.
Okay, so Regulation 56 mandates action. Articles 14 and 21 are being violated, and there's data showing an 80% value collapse. You'd think the court might just order immediate back pay or something drastic, but they didn't quite do that.
No, and this is where the ruling gets interesting. Strategic, maybe. They took what's being called a middle ground progressive stance. They did not issue an immediate mandamus, a direct command for revisions and payouts,
Why not? Too complex, too expensive.
likely recognizing the sheer financial scale and complexity. Ordering billions in immediate payouts could destabilize PSBs. So instead of demanding the money right immediately,
They demanded a plan.
a repeatable system, documented, standardized procedure that can be executed consistently and constantly.
Exactly. They directed the key players, the IBA, PNB itself, and the Department of Financial Services, to take structural action.
What specific action?
They ordered them to constitute a committee within 3 months, and this committee has to include actuarial experts,
Actuaries. Okay, to crunch the numbers properly.
right? And the committee's job to review and figure out parity-based pension structures, basically find a sustainable way to make pensions fair again, reflecting that deferred wage principle.
So the court is saying, we've established the constitutional need. Now you figure out the mechanics, but you have to figure it out.
Pretty much. It puts the onus back on the banking sector and the government bodies to engineer the solution, but under the court's watchful eye and with a deadline.
And is there a follow-up or just hope they do it? No, there's definite follow-up. They have to file a compliance affidavit detailing the steps they've taken. And the court explicitly scheduled the case for monitoring on January 15th, 2025.
So they have to report back.
Yeah.
The court isn't just issuing a ruling and walking away.
Awesome.
They intend to oversee the implementation.
That shows real commitment to seeing a practical outcome, not just a theoretical judgment.
Now, this decision didn't come out of nowhere, legally speaking. Did the court lean on previous cases' precedents?
Yes, definitely. They cited the classic D.S. Nakara versus Union of India 1983 case.
That's the one establishing pension as a right, not a charity or bounty.
Yes, foundational stuff. But perhaps more importantly for the practical side of things, they pointed to a much more recent case from 2023 involving the Reserve Bank of India, or RBI.
The RBI, how is that relevant?
Very relevant. That case, All India Reserve Bank Retired Officers Association visa Union of India, showed that the RBI had already implemented periodic pension updates.
So it serves as a proof of concept?
Exactly. It completely undermines the argument that, oh, this is just too complicated, too expensive, fiscally impossible.
Because the central bank itself is already doing it.
Right. If the RBI can manage its finances and update pensions periodically, it demonstrates that it's viable within the Indian banking sector. It provides a working model.
That's legally quite clever. It gives the banks a template or at least removes a major hurdle.
And it's why many believe this Delhi High Court judgment could heavily influence the Supreme Court in MC Singla v. PNB UOI.
So this Delhi ruling might offer a path forward for the Supreme Court in that case?
Potentially, yes. It offers a judicial model for balancing the constitutional rights of retirees with those tricky fiscal arguments. It shows a way to enforce the right without necessarily mandating a specific immediate financial sum.
Okay. So, recapping this deep dive, the Delhi High Court essentially activated Regulation 56, finding it requires realistic application to maintain pension value.
And crucially, it found that the proven dramatic 80% erosion of real income isn't just unfortunate. It triggers Article 21's protection for a dignified life.
Correct. And the remedy wasn't just a payout, but a mandate to build a system using actuarial expertise based on the functional RBI model.
That's the key takeaway for you. The court demands institutional creativity to solve this, guided by a successful example.
Which brings us to the final thought.
Yes, so the court points to the RBI's success as proof that updating pensions is possible. But here's the provocative question for you to think about. How do they adapt the RBI model without just falling back on the old excuse of, we don't have the money? That's the real engineering challenge ahead.
The Delhi bench issued the most human rights-based and forward-leaning decision among the three courts. It ruled in favor bank retirees on all counts. It also stated categorically that UOI and the banks violated Regulation 56, Articles 14, 21, and by implication the Constitution.
To wrap up, Delhi will most likely heavily influence Supreme Court reasoning in MC Singla, especially given convergence with DS Nakara and Article 21 jurisprudence. Thank you for watching. The next and final judgment in the series is from Chandigarh and will be streamed Tuesday 11th November. Please like and subscribe.